Hi students, today's topic is continuation of the Industrial Dispute Act 1947. In this act, in the last video, we have come across with the definitions and what are the settlement machineries which is being carried out in any industry. That is, we have come across with the term industrial conflict, which is we are talking as industrial dispute, and what are the main objectives of Industrial Dispute Act, and the definitions come across with what is industrial dispute, who is a workman, who are all not come under the workman heading according to Industrial Dispute Act, and what is an industry, and which are all not come under the heading of industry, and these are all the settlement industrial dispute prevention base. Starts from works committee, conciliation officer, board of conciliation, court of inquiry, labor court, industrial tribunal, national tribunal, according to the type of conflict and according to the type of industry or the number of workman in the industry. These are all the settlement machineries which is being carried out. We have come across all these topics in the earlier video. Now, the present topic which I am going to talk about is strike and lockout. This is also an important topic which we have to understand in the Industrial Dispute Act. That is, these two terms which we are talking in Industrial Dispute Act is very important in the sense when any dispute is being raised in any industry, the next level of the weapon which is being carried out by an employee and the employer is these two terms, that is strike and lockout. Then we'll go detail into the topic. When we come across with the word strike, actually this is the weapon which is being carried out by the employee. That means it the employee is going to seize the work by a body of persons that is employed in the form of a workman in combination or concerned refusal under common understanding of any number of persons means they are not ready to work in the organization which they are being employed. That is nothing but strike. That is any refusal which is being carried out by the industry authorities means then the weapon which is being carried out by a workman in the form of employed person, he will seize the work. That is termed as strike. According to the definition TQ, strike is being given in the Industrial Dispute Act. Relevant provisions related to strike if you come across in Industrial Dispute Act is section 10(3), 10A, 4A to 22 28. They are all talks about, these provisions all talks about strike. We'll see the general meaning of strike and lockout. That is a temporary cessation of ceasing of work by workers with a view to furthering protecting their interest and rights. I will give you an example. A worker is been having an issue or a dissatisfaction regarding the working conditions. He is raising that issue to the authorities. Then the authorities is rejecting his conditions. Then in that case he is approaching a union and he is going with a form of ceasing of the work. Then it can be termed as strike. Then if the strike is being continued, if the demands are not being accepted by the management and they are going to continue the strike of that is cessation of season, that is closing or temporary stopping of their work by workman, then what the next weapon is being taken by the employer is lockdown. That is what strike is the weapon of the employee, lockdown is the weapon of employer. Then here when employees try to seize the work, not to continue their work because their interest or rights is not being fulfilled or their demands is not being fulfilled, then they will go for the strike continuation. Then at that time employers is going to close the workplace, that is suspension of work or refusal by an employer to continue to employ it, because employees are going for strike, they will close that particular area to not to fulfill their needs or the demands which is being raised by the employees. That's why we'll say these are all the two weapons from the employee side and the employer side which is being carried out in any industry. Now, according to section 10(3), appropriate government can prohibit the continuation of a strike in connection with a dispute which is being referred as Board of Conciliation, Labor Court, Industrial Tribunal or National Tribunal. This government is having all the rights to stop the strike if the dispute is connected with the, that is as earlier I said about the settlement machineries. When the settlement process is being under the Board of Conciliation or in the Labor Court or in Industrial Tribunal or National Tribunal, then automatically government is having the authority to stop the strike, because under this proceedings, government is having the right to stop the strike. Why? Because this dispute is connected with the proceedings of these categories of settlement process. Then in that case, government is having to stop the strike. The same appropriate government can prohibit the continuation of a strike in connection with the dispute when it is referred to an arbitrator and a notification is being issued, means then also government is having all the rights to continue, that is prohibit the strike in connection with the dispute. That is what the section 10(3), 10A and 4A talks about. Then these are all the different forms of strikes which we have in the Industrial Dispute Act. Few has been mentioned here. That is authorized strike, that is legal strikes, what we can say, or with proper approval from the union or consent if they are getting, means that can be called as authorized strike. That is they are informing to the union and they are going with the strike, and that is whoever going with the strike option of the employee side, then that will be called as authorized strikes. Unauthorized strikes or wildcat strikes means without the approval of the union, strike by a section of workers on the spur of moment without any formal preparation. This is sudden unplanned strikes, what we can say is as unauthorized or wildcat strikes. Any formal notice to the employer or consent of the relevant unions, uh, if they are doing, means then this can be called as unauthorized. That is, they are not informing to anybody and without any proper plan they are going with the strike. General strike is wide coverage, that is usually any demands is being raised by the workman towards the employer, then these general strikes will happen depending on the confined to the city or the industry. These general strikes will go on. Particular strikes is limited to the scope of the people and also with industries, confined to a single plant or few plants under one single business. Work to rule strike. This is also a strike. Employees declare that they will perform their tasks strictly in accordance with the rules prescribed, may result in slowdown. According to the regulations, example, their working timing, their task is strictly restricted to one particular place means, then they will go with the work to rule strike. Ordinary strike, usually we can say it as picketing also. Workers quit their places of work and prevent others occasionally by violence but mostly by persuasion or picketing from replacing them in order to involve in the strike. This is what ordinary strike. Sympathetic strike, nothing but conducting out of sympathy for the cause of another group, whether on strike or not. That is to support the other worker. The sympathy strikes can be done by the employees. GRO, it is a term which is being used first in Mumbai. It is also one kind of strikes, what we can call it as confinement of authorities in their offices by workers to exert pressure on management to accept their demands. That is, it is also one kind of strike which is being done by the employees. And types based on techniques regarding strikes, if you do, that is, these are all which is being done during their workplace itself when they are going with the working timings. Slow down strike, that is, they won't stop the work but rather they slow down the pace of work, in the sense automatically instead of 8 hours work, maybe the hours has been reduced to 6. In that way they are showing their temporary cessation of their work in the form of slowdowning the operations. Quickie strike, workmen remain in their place of work but they stop work for a brief period for few minutes or hours. Maybe no, that particular time period production may be stopped. Because of that, it may give a loss to the employer. That is, the temporary cessation makes the employer get the loss out of the strike. Sit down strike, workers remain in their place of work but they don't work. This is what we can say it as sit down strikes. Duration is long as compared to quickie. Why? Because all these types of strikes voluntarily they won't cease, but no, this temporary cessation, it depends on the way they are working by slow downing or few hours or few minutes they are stopping their work or simply sitting in the workplace. All things we can say it as also as strike. Now coming to the public utility service under Industrial Dispute Act, this is also one of the definition which is being given in the Industrial Dispute Act, which can be called as public utility service. That is government sector only what we say it as. According to the definition in Industrial Dispute Act, any railway service or any transport service like bus, all kinds can be called as, that is government service transportations can be called as public utility services. Any service in major ports and docks, postal, telegram, telephone, industry which supplies power, light, electricity, water to public, sanitation, which is all specified in the first schedule of Industrial Dispute Act, which we can call it as public utility service. Other words which we understand is government sector. Now, regarding government sectors, general prohibition of strikes and lockouts is, or generally prohibition of strikes when it can happen means, no person should go or involve in a strike when in breach of contract, or no employer shall declare lockout during the pendency of conciliation proceedings before a board. As I said in the settlement machinery, a dispute can go with the process of conciliation officer. After completion of the proceedings, he will take the time of 7 days to submit the proceedings. Then, during that particular process, no employee or no employer shall go to the uh, topic or shall use the weapon of strike or lockout. That is what this section talks about. That is during the period of conciliation proceedings or before the pendency of proceedings of labor court, or when an arbitrator is proceeding before 2 months after the conclusion. That is simply, if you want to understand, before been involved in any type of proceedings means, then we should not go with the strike or lockdown. If it goes, then as earlier I said, it can be stopped by the government. Why? Because government is having all the authority to stop. When these are all the proceedings is been going on, no employee or no employer should use the weapons of strike or lockout. Don't think that here I am using the word weapon. Here this weapon is nothing but the act which they are doing in the form of strike or the lockdown. Right? That is what during the proceedings, no employee or no employer should go with the strikes and lockouts. Now, strikes and lockouts, when it comes to public utility service, uh, that is without giving to the employer notice of strike within 6 weeks before striking, within 14 days of giving the notice, before the expiry of the date of strike specified in such notice, or during the pendency of any conciliation proceedings, as earlier I said, before a conciliation officer, and 7 days after the conclusion of such proceedings, then also government is having right to prohibit the strikes and lockout with regard to public utility service, that is government sectors. That is what section 22 talks about. That is government is having all rights to stop the strike or lockout if they are going without informing with the employer, or without notice, or without 6 weeks prior intimation, within the 14 days of giving notice. All these cases, they can able to prohibit the strike or lockout. Then no employer carry on the public utility shall go for lockout. As earlier I said, the same it is applicable for strike and lockout. It comes under section 222.2. That is prohibition of strikes talks about 22.1. Prohibition of lockdowns talks about 22. Employer's obligation is to inform the appropriate government about any notice of strike received from the workman, or any notice of lockdown given to them within 5 days of receiving or giving such notices. Why? Because it is the duty of the employer to obey or to abide with the regulations with regard to strike or lockout out. Why? Because this has to be maintained as a document or a record regarding the Industrial Dispute Act. That is what this employer's obligation is, to inform the appropriate government. Now, exemptions are there regarding the strikes and lockout. That is, notice of lockdown is not necessary when strike is already in existence, but intimation of the same is to be sent to the authority specified by appropriate government. This point talks about when people already going with the strike, and it automatically implies that employer is going to close the industry. That is not required of giving as a notice to the government, but they have to inform with the uh, appropriate government. Then notice of strike is not necessary when lockdown is already in existence, but intimation of the same has to be. It is vice versa what we talk about lockdown and strike. It is the duty of the appropriate government to be informed as employer side and also with the employee side. Then coming to the illegal strikes and lockouts, a strike or lockout shall be deemed to be illegal if it is commenced in the controversial section of 22 or 20. That is, as we earlier we talked about this strike and lockout where a public utility service or other than public utility services is being strictly prohibited to go with strike means, then in that cases it comes under illegal, that is without proper notice or without proper information or without proper proceedings uh, time period. If they're going with the strikes or lockouts, then it can be called as illegal strikes. In case of arbitration, strike can be prohibited. A lockdown in consequence of any illegal strike is not illegal because the weapon which is being carried out by the employee in the form of illegal strike can be stopped by the employer in the form of lockdown. Then that cannot be taken as illegal lockout. It is not illegal, it is legally approved by the government also because they are not getting proper permission going with the strike. Because of that, it can be cancelled or become void in case of employee side. They are going with the illegal strikes. Then during the strike period, no person shall knowingly spend any money to support an illegal strike or lockout. What this is what the prohibition of financial aid regarding the Industrial Dispute Act. It is strictly avoided with any spending of money regarding the strikes or lockouts. That is to uh, create or to form this type of illegal strikes or lockout. Strictly financial aid, that is exchange of money in the form of to encourage these illegal strikes or lockouts, can be strictly prohibited by the government. That is, it can be considered as according to sections, it is not, it should not be followed by the employee or the employer. Then other terms which we come across in illegal strike is in Industrial Dispute Act is layoff under section 2K. That is, this is also one of the area where the next level of industrial dispute may rise is layoff. That is, an employer is going to refuse or unable to give opportunity to the employee in the form of unemployment because of shortage of coal, power or raw material, accumulation of stock, breakdown of machinery, natural calamity or any other connected reasons to give employment to a workman whose name is in the muster roll as a registered workman of industrial establishment or and who has not been retrenched means, then that will be considered as layoff. That is a situation is being created by the employer in the form of unemployment to the employee because of the reasons and they are unable to give the raw material to produce the products by the employee, or they are not having the stock to go with the working conditions, or machinery is being breakdown and the employer is unable to go with employment option, or any natural calamities happens in the form of disasters means, then also employer is unable or refuse to give the employment, then that can be termed as layoffs. Layoff is always be termed as very temporary process, but this temporary process is going to continue by the employer, then employee is going with the option of strike, because uh, frequency of going with layoffs by the employer is being carried out, then in that case what employees is going to do is they will go with the option of strike, or first they will they will raise as a dispute and they will go for negotiation process, or they will go with the collective bargaining process, and if it is nothing is going to happen means, then the next option they will take is strike. And layoff results in temporary employment only, as I earlier said. Then layoff is not applicable for with particular establishments in which less than 50 workmen on an average per working day have been employed in preceding calendar month, which is a seasonal character, or in which work is performed only intermittently. Then also this layoff is not applicable with respect to Industrial Dispute Act. Then, in accordance with the Industrial Dispute Act, other one important term which we have to check with this is continuous service with regard to employees. That is, uninterrupted service can be called as continuous service. That means they should not be interrupted on account of sickness. That is, for example, I am working in an organization for 240 days in a year. Then during these 240 days of year, my uninterrupted service should not affect because of an accident or sickness or authorized leave, any legal strike I'm been involving in the process of my service, or any lockdown, or any cessation of work without the fault of workman. All these cases, if my service is being interrupted, then it can be it cannot be considered as continuous service. That is what that means. Continuous service, if you are talking all the service should not be interrupted, then it can be said as continuous service. If nothing is being affected means, then we can say it as continuous service. Here you may raise a question of, if we are taking a leave, all these cannot come under uninterrupted service. Uninterrupted service, when it happens, means without the fault of ours. If any cessation of work is been happened and you are abiding with that interrupted service means, then it cannot be considered as uninterrupted. Uninterrupted cases only accounts of not proper information, not going with legalized versions of strikes, or sickness or accident, whatever it be, then in that case we cannot say it as continuous service. That is, continuous service of 1 year, as I said, example, in 12 calendar months, actually working from at least 190 days, 240 days, and other cases. That is why this 190 days is being given means, few establishment may work on seasonal basis. In that case, they will consider a continuous service of 1 year in the days of 190. The number of days on which workman has actually worked shall include laid off, leave with full wages, absence due to temporary disablement which is being properly authorized, or accident which is aroused out of employment, or any maternity leave of maximum of 12 weeks. All these conditions comes under continuous service of 1 year, which is being acceptable. And right of workman laid off for compensation, when we talk about when an employer is going for the layoff, then during that particular case how the salary can be given is what the right of workman which is going to get as compensation. A workman other than Badali or casual workman whose name is in the muster roll. When I say muster roll workman means then he is properly registered and he is come under the heading of workman, and who has completed 1 year of continuous service. If he is being laid off, then he has to be entitled to go with the 50% of total wages and dearness allowance regarding the compensation. This is what the rule, or this is what the regulation which come under Industrial Dispute Act. If workman is laid off for more than 45 days, no compensation is payable in respect of any period of layoff after expiry of first 45 days. This is when, as I said, no layoff is being continued for more than 45 days. Then, according to Industrial Dispute Act, no compensation is to be payable. It is lawful for the employer to retrench the workman at any time after expiry of 45 days and compensated accordingly. This is also happens legally in terms of Industrial Dispute Act, that employer can retrench. That is, retrenchment is also about uh, making the employee not to continue with his employment. That is what we say it as retrenchment. This is also happens because of the economic conditions of the industry. In that cases, it is also lawfully correct from the side of employer according to Industrial Dispute Act. In that case, retrenchment happened means he has to compensate properly after that expiry of that 45 days. Why? Because proper settlement has to be given by the employer to the employee when he is being retrenched. That is what, these are all the rights which a workman is having regarding layoff. Workman not entitled to layoff compensation when if workman refuses to accept the alternative employment in the same establishment, because in one particular plant they are unable to provide the employment because of raw material shortage or breakdown of machineries, an employer is going with an option of other employment in other establishment. Then he is refusing means, in that case this layoff compensation is not being entitled to the workman. Stated within a radius of 5 miles if the employment, that is the conditions they are saying, if other alternate employment is being provided by the establishment which should be within the radius of 5 miles to come for the work regarding the workman itself. That is, they are giving a distance of the place where he can able to come to the work in during the period of layoff situations. Then that cases he cannot say it as I cannot come with the uh, within that particular establishment which is having 5 miles distance means, then those cases he is not being entitled to give the compensation. If he does not present himself for the work, or if layoff is due to strike or slowdown, then also compensation cannot be given to the workman. Then, as I said, retrenchment, it is also one of the term which we use in Industrial Dispute Act. As I said, it is terminating the employee by the employer for the services, but the reason of uh, other than punishment inflicted by way of disciplinary action, but does not include termination due to all these things. Termination only happens because of other reasons, that is, they are unable to run the industry or they are unable to provide the proper working conditions. These are all the cases retrenchment may happen. Otherwise, if a termination is being given because of voluntary retirement, superannuation, non-renewal of service contract, or continued ill health means, then that cases it cannot be called as retrenchment. It can be a separation from the employer, or we can say it as resignation, we can say it as layoff, we can say it as other terms based on the disciplinary action it is being taken, suspension, or like that. That is what retrenchment. It is termination which happens. Reasons may be different regarding the retrenchment by the employer. It cannot include the conditions which is being given below. That is, when retrenchment they are going with means conditions precedent to retrenchment is no work on employment at least 1 year can be retrenched unless service 1 month notice indicating the reasons for retrenchment. This has to be followed by the employer when unnecessarily a person who is having a continuous service of 1 year, if it is being retrenched and without proper notice by the employer is being done with regard to this retrenchment process means this has been paid with compensation at 15 days average pay for every completed years of continuous service or any part thereof in excess of 6 months, or notice to the appropriate government has to be followed when they are going with the process of retrenchment. This is the general procedure which has been followed by the government. Employer as should apply for the permission with appropriate government. Copy to the workman also should be given when they are going with this retrenchment process. Appropriate government may inquire why the particular workman has been retrenched, present their cases, and decide whether retrenchment is genuinely required or not. As I said, economic conditions they are unable to provide an employment and they are giving retrenchment to few of the employees. Take example of 50 employees is being given retrenchment. Then in that case, a proper government can inquire about the retrenchment decisions which is being taken by the employer, and if it is genuine then they will ask them to go with the retrenchment process. Otherwise government may declare that retrenchment should not happen or retrenchment should be stopped, then we have to abide with the government rules. After the passing of the proper government, an order granted or refusing the permission of retrenchment, that copy has to be given, communicated with the employer and the workman. This is what the general procedure when they are going with the retrenchment process. Principles of retrenchment means how they go with that retrenchment or termination of employer process means last come first go. That is, people who are coming in the last continuous service year means that person will be going first. Unless the employer record the reasons retrenching any other workman is being clearly given, then only this principle has been followed under section 25G. Another important term which we have to come across is closure. Closure, when I talk, the company, that is the industry which is unable to run the industry because of any of the reasons of maybe uh, they are regularly going with layoff conditions, they are unable to run the company, they are going with retrenchment processes, all these cases, then what they try to do is they will close the industry itself. That process what we say it as closure. Permanently they are closing a place of employment or part thereof, which is being termed as closure. When they are going with the process of closure, 60 days notice has to be provided under section 25 FFA. This notice of intention to close down an undertaking is to be given appropriate government 60 days before the intended date of closure, and this condition is not applicable to the undertakings if employee are less than 50 members, or if the construction of roads, bridges, or canals or other construction work means no need of going with the proper notice. Then government can grant exemption from the requirement of notice period under exceptional circumstances. That is, no major accident has happened in the industry and they are unable to run the company means, then in that cases there is no need of going with the notice period also. That is, that 60 days of notice period is also not required in the case of closure. I will continue with the next video. Thank you.